Hello, my name is Grant Fritchey. I work for Redgate Software. So I'm reading the new California law, the California Privacy Act, and interesting stuff. You guys should probably take a look at it. First up, it doesn't have teeth. There's let's get it right here. You can sue yourself. Individuals can sue. And the teeth that it has is that, so I could sue, but the amount of money I could get if I sue, Google, is $750. Okay, great. That's per instance. So I guess if Google violated the law 10 times, I could get $7,500. If they violated it 100 times, I get $75,000. That's all cool. But, it's not a whole lot there. And the highest penalty per violation levied for the law, so that, because I can get 750, the government can get 7,500. Yay. It doesn't look like California is taking this really seriously. They've put in, the laws, but there's no teeth. And so I don't know how they're going to enforce it. Now, I'm still just reading the law itself, and I recommend you track it down. And they've got, the rights are all broken out. The purpose and intent is to further the constitutional right of privacy by giving consumers a way to protect their personal information. So you've got the right to know what information is being collected. That's cool. It's very similar to the GDPR. You have to, as an organization, you need to document what information you collect and let people know what that is. Okay, easy to understand. The right to know whether your personal information is sold or disclosed, and who it is sold or disclosed to. Interesting. Now, enforcement on that could be interesting, and we'll see how that goes. There's details. I'm not going to read all the details right now. The right to say no to the sale of personal information. So you can allow an organization to have your personal data, but you can tell them that they can't sell it. Interesting. Right to equal service, compliance with the right to know, blah, blah, blah. Notice requirements, yeah. So if you've opted out, 12 months. If you opt out, they cannot sell it for 12 months, but then they could request again whether or not they can sell it. Interesting. Let's see, biometric data, they start defining it. Physiological, biological, or behavioral characteristics, including your DNA. They can be used singly or in combination with each other. See, that's the trick. When you start talking about personally identifying information, it's not simply, I have green eyes. It's a combination of I have, this ruddy reddish skin and green eyes, gray hair, some brown hair. I'm 6'1". All of this stuff taken together, you start to get, oh my gosh, that's that person. So it's the combination of things. But it's, biometric data includes, but is not limited to. I always love it when the legal definitions say it's all these things and some other stuff that we're not going to tell you about. Iris, retina, fingerprint, face, hand, palm, vein patterns, and voice recordings. Hey, look, this is personally identifying information. My name is Grant Fritchey. From which an identifier template, such as a face print, a minutia template, or a voice print, can be extracted. And keystroke patterns or rhythms, gait patterns or rhythms, sleep, health, exercise data can contain personally identifying information. Oh my God, they're checking my gait. Wow, this is a lot of stuff going on here. Let's see, debugging to, there's a lot I'm going to have to read. There's a lot you're going to have to read. Home page. Oh my gosh, they're psychometric information. Wow. Let's see, exemptions. Okay, so if you comply with state, federal, or local laws, okay, that makes sense. Complying with civil or criminal or regulatory investigation or subpoenas, cooperating with law enforcement, collect and sell consumers' personal information if every aspect of such commercial conduct takes place wholly outside of California. Commercial conduct that takes wholly outside of California is the business. If the business collected such information while the consumer was outside California, no part of the sale of consumer's personal information occurred in California, and no personal information collected while the consumer was in California is sold. Interesting. Okay, cool. So unlike the GDPR, where it's my citizenship defines everything, this is where is it taking place? Interesting. So, a lot of stuff going on. Enforcement by consumers, enforcement by public entities. Let's see, consumer privacy flawed, whistleblower enforcement. I do like that they've got the whistleblower protections in place. Security breach. They define that somewhat. We're gonna have to read some more on that. That's gonna be a big one. Oh God! Nothing in this act shall prevent a city and county, municipality, or local agency from safeguarding the constitutional rights of privacy by imposing additional requirements on businesses regarding the collection and sale of consumers' personal information by businesses, provided the requirement does not prevent a person or business from complying with this act. Oh my God! So, San Francisco or Berkeley can add a whole bunch more stuff. Oh my God! Oh man! That's not good. That's not good. Conflicting initiatives. Who has standing? 20 pages worth of stuff. I'm going to have to read it all in detail. I'll get back to you. More to come on this whole California Act. The biggest question I have right now is when does it take effect? Is it in effect right now, or is it is the enforcement effect coming up later? Because you've got to have at least some time to meet the compliance. I've not found that detail yet. So that's the one I'm trying to track down. I'll get back to you on that. But anyway, my first reading, just getting into the whole California Consumer Privacy Act and CCPA, something you guys are going to want to read more about. My name is Grant Fritchey. I work for Redgate Software.